Welcome everyone to another employment rights question and answer session. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin out of our firm's Ottawa office, but I assist clients throughout all of Ontario. I'll be here for the next 30 minutes in order to answer all of your questions. So any questions that you have about employment law, workplace issues, vaccine mandates, COVID, layoffs, severance, health and safety, you name it, I'm here to answer it. So if you have any questions that you have been wondering about over the last little while, now is the time to send them in. Like I said, I'll be here for the next half hour or so to answer all of your questions. So send them in and I will get to as many questions as I possibly can. As I mentioned, I'm here in Ottawa, and Ottawa has been in the news a lot lately because of the convoy, the Freedom Convoy, and the trucker protest that's happening at Parliament. So we've, of course, in our Ottawa office, been getting a lot of questions about that as it relates to employment issues. We've had questions from people wondering about, retaliation or reprisal based on participating in protests. So if you have any questions of that nature, please send them in. Happy to answer those questions. It certainly has become a hot topic in the last little while. All of the vaccination issues have obviously become very prominent, and we're getting lots of questions about that leading up to this protest being the newest thing that we've had in the news. So any questions about any of that at all, send them in. Again, as it relates to your employment, happy to answer those questions. While we wait for the questions to trickle in, as always, I have a few topics that I've prepared to talk about based on things that we get asked about a lot, things that have come up a lot over the last couple of weeks since I last did a question and answer session. So I'm going to go forward with talking about a few of those things and giving you some information that hopefully will be helpful moving forward, since it's something that we've been asked about a lot. But I'd much rather be answering your questions. So send in your questions, whatever the questions are, happy to answer them. So obviously one of the main issues that we're dealing with now in employment law, and something that we've been getting a lot of questions about, is the vaccine mandate. And a lot of employers implementing vaccine mandates and vaccine policies into their workplace. This has become, I'd say, the hot issue in employment law over the last few months, and we've been fielding questions, emails, calls from so many people about all of these issues, whether it's vaccination, testing requirements, whatever the case may be. This is what's been coming up a lot. And so I see we have some questions coming in. And so what I was going to say about that in particular is what's really important to keep in mind before I get to the question that just came up is these are called mandates because they're mandatory vaccination policies. But it was a very good question that was asked to me a couple of weeks ago in my last question and answer session, where somebody was asking about, what is a mandate? Is it a lawful mandate? Is it the law? What's the status of these things? And it's really important not to confuse a law, which is created by the government, that forces vaccination to continue working. And that only is something that would be in long-term care homes in Ontario. That is the only industry where the government has mandated vaccination in Ontario provincially. Other than that, it's a policy. And it's a policy that the employer is implementing into the workplace and wants all of the employees to comply with it. Now, whether that policy is reasonable, necessary, what happens to you as an employee if you don't comply with it, all of those questions are things that we can answer depending on the circumstances. But what I can say first and foremost is if there is no government mandate, there is no law forcing someone to be vaccinated in order to continue working, then there cannot be a continued employment based conditionally on vaccination. In other words, if you're put on an unpaid leave, suspension, if you're let go because you won't be vaccinated in an industry where there doesn't have to be vaccination as mandated by the government, then you would be owed severance. And that's what we've been assisting people with over the course of the last few months. And I expect as time goes on, we will continue to assist people with these issues. So I wanted to make that very clear in terms of a policy versus the law. but every single case is different. So if you're in a circumstance where you're not quite sure, is this the law? Is it a policy? Do I have to do this to continue working? What are my options? What are my recourse options? Get in touch with us, and we're more than happy to assist you. You can email us at help@employmentlawyer.ca. You can go to employmentlawyer.ca and contact any of the lawyers directly by getting our contact information off our website. And there's also a phone number that you can call. So there's many different ways you can reach us to make sure that you're protecting yourself. So I'm going to get to the questions that we have coming in now. I have a question from Mark on Facebook who asks, if my employer coerced me into getting vaccinated and I now find myself frustrated and angry with my employer, can I claim they have created a hostile work environment? So one issue really has nothing to do with the other from a legal perspective. So if you decided to get vaccinated, if your employer had a policy with respect to mandatory vaccination and you decided to get vaccinated, that's occurred already. Nothing we can do, going back to that, going backwards. Now, the second issue is you find yourself frustrated and angry with your employer. If you're frustrated and angry with your employer because you received a vaccination, and that's the reason that you're upset with them, that's not something that would create a toxic or hostile work environment at law that would result in there being, definitive legal recourse there. So if there are other things, and it's not clear, Mark, based on your situation, there may be other things that are happening at work. If there's bullying, if there's harassment, those are the types of issues where if they do meet a certain threshold, and it is a relatively high threshold at law to meet, but if there's bullying and harassment that meets that legal threshold in order to constitute a toxic work environment, then that's something that certainly, we could assist you with. Usually when there is a toxic workplace, there are different options that somebody can utilize in order to assist them. So the first step, which I always advise people when people contact me about issues they're having at work, whether it's somebody, harassing them, or they feel like they're being set up to fail, or somebody's just, not being nice, whatever the case may be, we get these issues that come up often. We have consultations with people about these issues. And my first recommendation is always to try and deal with it internally, meaning speak with the proper person who's appointed to address these things. And usually it's HR. If your company doesn't have an HR representative or an HR department, there will be someone else who should be appointed. There should be a policy, a process that needs to be followed to report these issues. That's step one, is file an internal complaint. And when you're going to do that, you're going to do it in writing, always in writing. So even if it feels like, it might take a lot of time or a lot of work to reduce all of your thoughts or all of your issues to an email, it's important that you do that, because that's your proof moving forward that you've actually brought it to their attention and that you've outlined all of the issues that are happening. Once you do that, then the employer has an obligation to investigate, to look into these issues that you've raised and to determine if there is actually workplace harassment going on at work, if there's a toxic workplace that's been created at work, and if so, what they're going to do about it. So they'd have to do something to stop that from happening moving forward and address any bad actors, anybody who's engaged in harassment. There needs to be action taken. If the employer doesn't do that, or if they do it but they don't do it properly, then your next step after that in terms of escalating it could be either going to a lawyer and having a lawyer like ourselves get involved to assist you. Oftentimes you send a letter from a lawyer and, we set out what the issues are, and usually that does assist in remedying the issue. Alternatively, you can also file a complaint with the Ministry of Labor. Now, when you're filing a complaint with the Ministry of Labor for that type of issue, it's under the Occupational Health and Safety Act, and there could be a few different reasons for that type of complaint. It could be, like I said, the employer failed to investigate altogether. So your complaint to the Ministry of Labor would be they failed to investigate, and then the ministry would come in and do their own investigation. And they would either make the employer investigate or do their own investigation altogether and find out what happened and then make a recommendation and a finding at the end. So you have those options. And if you do bring it to your employer's attention first and they do nothing about it, or they do something but then it continues and they're not putting in the work that's required to prevent any misconduct, harassment, toxicity in the workplace from continuing, then at that point you should absolutely be consulting with an employment lawyer. I help people deal with this issue all of the time. And sometimes it does rise to the level where you just can't keep working there anymore. As I mentioned before, some of that misconduct, some of those issues in the workplace can be addressed internally, and they don't quite rise to the level that would constitute harassment at law, but sometimes it does. And when it does, and it's to the point where the person cannot keep working there from an objective perspective, that's when you can potentially claim what's called constructive dismissal. That's when something that your employer has done in terms of changing the terms and conditions of your employment makes it so that the employment relationship cannot continue. So in other words, it's as if they're firing you or letting you go without actually saying you're fired. Now, classic examples of this are your employer reducing your pay by, let's say, 30%. That's a clear-cut constructive dismissal. That's your employer making a significant change to a fundamental term of your employment without your consent. And so the employment relationship cannot continue. You can treat it like a termination and go after severance. That's a more classic example of a constructive dismissal. But constructive dismissals can also exist when it comes to workplace health and safety, harassment, toxic workplaces. If your workplace is so toxic that you simply can't work there anymore, and like I said, certain conditions would have to be met. It's not every situation that would amount to a constructive dismissal, but if it does rise to that level, then you can pursue it as a constructive dismissal on the basis that the employment relationship cannot continue because the workplace is just too toxic. It's so toxic that you can't keep working. And then you would pursue it as a constructive dismissal and go after your severance. So just getting back to your question, Mark, I wanted to explain all of that because I'm sure a lot of people that are watching today and who will watch this video after the fact have dealt with these issues. These types of issues come up a lot. Frustration with employer, feeling like you're not heard, feeling like management is not doing what they're supposed to be doing. And then there are, harassment issues, bullying. These are all things that do come up often enough. It's a question of knowing how to deal with them and dealing with them in a prompt manner so that you're not, a year later still dealing with these issues. You always have to deal with them as they come up and make sure if you're not sure what to do, you get advice from a lawyer because we can always advise you on what's your best next step. What are your options? You just don't want to be in a situation, like I said before, where you're putting up with an unhealthy workplace situation for longer than you have to. So Mark, if there are other issues there, like the ones I've mentioned, certainly there can be a hostile work environment created. You may have some recourse options there. It would really depend on the exact circumstances in which you find yourself. But just the fact that you received a vaccination following your employer implementing a mandatory vaccine policy, that in and of itself does not create a hostile work environment that would constitute a constructive dismissal, for example. So it's important to know the distinction between all of that. So I'm going to move on to more questions that we have here. The Dreamer on YouTube asks, can an employee still receive severance pay if both the employer and a third-party client mandates the vaccine to come into work? Great question, and this is one that we're getting a lot. So the situation that is being asked about is and we've seen two different things. We've seen employers implement mandatory vaccine policies, in which case it's the employer that's saying you need to be vaccinated to keep working. And then we've also seen where maybe the employer doesn't implement the policy, but there's a third party that does. So for example, if you're in the service industry and you are going to different clients' workplaces and you have contracts, your company has contracts with other companies to attend at their workplaces, and those customers have implemented a mandatory vaccine policy. So they're actually the ones that are preventing the unvaccinated individual from working. you then would not have recourse against your employer, because it's not your employer that's stopping you from working, it's a third party. And if it's a third party that's preventing you from working, there would be a situation of what's called frustration at law, because it's due to no fault of yours or your employer's technically, but you aren't able to work because of the actions of a third party. So you wouldn't have recourse against your employer in a situation like what I've just described, where it's a third party mandate. Where it's a different situation, which is what the dreamer was asking about, if it's the employer and the third party, well, at that point, whether the third party has a mandate in place or not doesn't really matter. It doesn't really become relevant, because the employer has the policy in place. So the only time that the third party mandate becomes relevant is if the employer doesn't have their own policy in place. Because if they do, then your recourse potentially would be against your employer. Your employer is putting the mandate in place. Now that assumes that there's no government mandate. So for example, if your employer has put a policy in place, but it's a federal government employer where the law has now changed such that you have to be vaccinated, that's different. You wouldn't have recourse there, unfortunately, from an employment law perspective, because the government has changed the law to require that federal core public administration employees have to be vaccinated in order to continue working. But when we're talking about the private sector and we're talking about just policies, not law, not mandates by the government, if the employer and the third party both have mandates, then you're just looking at the employer mandate for the most part. So if the employer has put in a mandate and they have let you go because you're not vaccinated, then you would be owed severance, with the caveat that if the third party has made it impossible for you to work anyway, the employer may have a defense to that. The employer may have a defense to be able to say that, you wouldn't have been able to work anyway. However, as an employee, you'd be able to say, that's fine, I don't need to continue working. You could have just put me on an unpaid leave until this all blows over, until things change. So if you're actually having your employment terminated because of that, when you don't have to have your employment terminated, then there is an argument for severance still in a situation like that. So as you can tell, there are so many different types of situations that have come up from these issues, and it's really important to get advice from an employment lawyer about your particular situation, because depending on government mandates, employer policies, third-party mandates, all of these things can change whether somebody has legal recourse and what options they may have as legal recourse. So you want to make sure that before you make any decisions, before you do anything that can prejudice your legal position, you make sure that you get advice from an employment lawyer so that you know where you stand and you can make an informed decision about what you want to do. I have a question from JC2004 on YouTube who asks, could it be argued that by requiring a vaccine that someone may not have been comfortable with count towards a stress leave? I'm not sure that I understand your question. What I can say is that, mandatory vaccine policy, just the implementation of that policy itself, would not justify a stress leave per se. But if you are negatively impacted and you have a medical condition for which your doctor can support and provide a medical note that says you're unable to work for medical reasons, then you'll be able to go on medical leave. So at any point, and that's true of any time, if you are suffering from a medical condition that's preventing you from working, you need to provide a medical note from your doctor that says that, provide that to your employer, and then you go off on medical leave and they have to hold your job for you. So that's true of any type of situation, regardless of, vaccination policies or not. Certainly you have that right, and you have that available too as an employee when dealing with any sort of medical issue. . 。 . 。 . 。 . . . 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. 。. .
。 . 。
Just reading through all the questions we have here, trying to get through them. So I have a question from Beth on Facebook who asks, does the Supreme Court ruling from the US saying that occupational health and safety is not an acceptable reason to implement sweeping vaccine mandates in workplaces over 100 people have any influence on the court decisions here in Canada? I know the laws are different, but would it be taken into account? For example, can you sue your employer for implementing an unreasonable condition of employment? It's a great question, Beth. Technically speaking, from a legal perspective, it won't have an influence. In other words, the courts in Canada are not bound by decisions outside of Canada or in the US, more specifically, as you pointed out. I know we're all kind of well aware of this decision from the Supreme Court in the States regarding this issue. It's likely that, this vaccination issue in some capacity will end up going to the Supreme Court of Canada. But it does take time to get there. So in the US, it seems that this issue was able to get to the Supreme Court pretty quickly, especially as far as Canadian standards are concerned. Usually in any type of regular case in Canada, for something to go all the way to the Supreme Court takes many years. So it's unlikely that we'll see a similar decision come out of our Supreme Court very soon. Having said that, there might be some influence there. There may be, it may be that depending on the case, whoever's in front of the court could use the Supreme Court and try to use that as an argument that the same thing should be found here. Certainly it does happen on novel legal issues where the courts haven't really made decisions on these issues before. If another foreign jurisdiction has made decisions on it, sometimes lawyers will use that to bolster their arguments. But the court isn't technically bound by the decisions in other jurisdictions. So as it stands, I can't comment on the law in the States, but as it stands here, there is no right, as you mentioned, to kind of sue your employer for implementing an unreasonable condition of employment. But the recourse that does exist is if your employer is forcing or wants vaccination to become a condition of employment moving forward, and you refuse that, that's where the legal recourse comes into place. So it's not so much that you would be suing your employer for implementing the policy, it's that you would be pursuing legal recourse for the fact that your employer has now put you on leave or outright terminated you. But either way, it's essentially a termination of your employment because you refuse to comply with that policy. That's where we're at in Canada. That's the legal recourse that's available to you. And the damages are there. So if, and when I say damages, I mean severance. So if you're in a situation, as I mentioned earlier, where you've been put on an unpaid leave or an unpaid suspension for not complying with an employer's mandatory vaccination policy, or you've been terminated for cause, you are owed severance as long as there's no government mandate in place that forces that to happen. And so that's your legal recourse. So certainly there are things you can do. We'll see what happens. It certainly is interesting, in terms of the Supreme Court decision in the States. And I'm sure, like I said, we're going to see more cases come out of the courts as time goes on, but it does take time for these cases to get to hearings. And that's why for a lot of these cases, we may only end up seeing the courts deal with them once things are very different than they are right now. We may end up in a situation where this becomes endemic, months into the future, and people are not, concerned with vaccine mandates like they are right now, but these cases are still going to end up going to court to deal with these issues months after the fact, because it's such an important issue. I have a question from Zay on YouTube who says, can a company set your severance to $500 if they let you go for not getting the jab? So regardless of the reason, there's not going to be a reduction in severance because you didn't get vaccinated. So whether you were let go for failure to be vaccinated or let go for some other reason, as long as there's no cause to terminate your employment, you're owed severance pay. And when we're talking about cause, a lot of employers have terminated employment allegedly for cause because of the refusal to be vaccinated. But in most cases, it will not amount to cause and you will still be owed severance. So when we talk about severance in situations where somebody has been let go or put on an unpaid leave for refusal to be vaccinated, the severance would be the same as any other type of termination. And it will vary depending on your age, your length of service, and other factors. It will vary. You can always use our tools that we have available. We have a free severance calculator. We have a pocket employment lawyer, pocketemploymentlawyer.ca. You can go to that website and you can find out what your severance could potentially be. It provides a good estimate, but it's no substitute for speaking to a lawyer who can tell you exactly where your entitlements will lie. But certainly $500, I mean, depending on how much you get paid, $500 I can almost guarantee will not be enough money, because even under the Employment Standards Act, there are bare minimums for what an employer has to provide just as a starting point for severance. And the minimum after 3 months of service up to a year is 1 week. Beyond that, it starts to increase. Between 1 and 3 years of service, it's 2 weeks. And then beyond that, it's 1 week per year, up to 8 weeks. So even if you were only with a company for under a year, but more than 3 months, the odds are you'd still be owed more than $500. So if you're in a situation where you've been terminated and your employer is only offering you $500 for severance, that certainly is not enough. And it's not going to be enough in almost any situation, unless, like I said, you're in a situation where your employer had cause, which means you'd be owed nothing. But that would only happen in situations of egregious misconduct, very, very serious misconduct, which would justify the absolute capital punishment of employment law, no severance. Most situations are not going to justify that. So I have a question from Cecilia on YouTube who says, can an employer hold your pay and make you beg for your pay on your payday? That's a very easy one, Cecilia. The answer is no, they can't do that. If you've worked, you're owed the money that you should be paid. You're owed your pay. If that's happening to you or someone you can file a complaint with the Ministry of Labor for unpaid wages. And just the threat of doing that to your employer may be enough to just get them to pay it out to you. You can mention to them, okay, if you don't pay me, I'm just going to file the complaint with the Ministry of Labor. And most employers don't want that to happen because they don't want the Ministry of Labor to start digging into their affairs. And so simply the threat of doing it may be enough, but if not, you can go ahead. You don't need a lawyer. It's free. You can file a complaint with the Ministry of Labor for unpaid wages. They'll investigate. And as long as that money is owed to you, they'll order the company to pay it to you. Okay. So that's a really good way of forcing them to do that. When it comes to severance, we never recommend going to the Ministry of Labor because they can only get you a very bare minimum amount under the Employment Standards Act. And most people are owed much more than that. So we don't recommend it in those situations. We always recommend discussing your situation with a lawyer. But for things like unpaid wages or overtime, simple things of that nature where that type of money is owed, those are the types of things where it's fantastic to go to the Ministry of Labor because it's free and they can deal with that on your behalf. I'm just seeing if I can get to a few more questions. We're almost at our time for today. So I have a question from Julie on Facebook who says, in regards to the mandates, are employers in a position, a duty to accommodate if a third party requires vaccine status? That's a great question. So what we're talking about is if it's a third party that's requiring the vaccination as a condition to enter the premises, but it's not your employer that's requiring it. So there would be an accommodation process that should be possible in a situation like that with the third party. So it's not necessarily the employer that would have to accommodate, but they could, and the third party as well. So it's an interesting situation, and I'd say that it's a collaborative accommodation process, which means that there'd have to be a collaborative accommodation process undertaken between the third party, the employer, and the employee. If there is really a situation where the employee cannot be vaccinated. And what I'm talking about is, if you have an allergy to a component in the vaccine, if you have a health condition for which your doctor has said, no, you cannot be vaccinated, then you need to provide a medical note to confirm these things to the parties that we're dealing with. And then the accommodation process is triggered at that point. But certainly there is accommodation that should be possible in situations like that, even if it seems a little trickier than the usual just employee-employer relationship. That fact that third party is there does not mean that there's no accommodation available. There has to be a process that's undertaken by all parties involved. Now, I know there's a few questions that I haven't gotten to. We're just over our time now, so we'll leave it at that for today. But as always, if you did not get your question answered, there are many ways that you can contact us. You can go to our website at employmentlawyer.ca, email us at help@employmentlawyer.ca, and you can also go to our website at employmentlawyer.ca and contact myself or any of my colleagues. All of our contact information is there, so feel free to get in touch, and we will get back to you and help you however we can. We also have more question and answer sessions next week, and I do believe the next one is Monday, if I'm not mistaken, but we have them throughout the week, so feel free to tune in again and ask your question at that time. So thank you everyone very much for tuning in. Thank you for all of your questions, and I hope that everyone has a wonderful weekend.